I want to tell you about a family that we just worked with, and we'll call the husband Tom. And Tom had spent 35 years building his retirement accounts. He was a disciplined saver, smart investor, and he ended up having just over $1 million in that account when he passed away unexpectedly at age 68, which unfortunately happens all the time. His wife, Carol, came into our office a few weeks later, and obviously she thought the IRA would just transfer to her automatically, right? They were married, and she thought that's the way it worked. And she thought that the kids would eventually split whatever was left. And she thought that everything was fine. And I keep saying thought because it wasn't fine. And the reason for that is Tom had never updated his beneficiary designation after they got married. So this is real. His ex-wife from a marriage that ended 20 years earlier was still named as the primary beneficiary on the account. Okay. And again, that's a real situation. It's more common than you'd think. Some of you are thinking that's crazy. How's that possible? It happens, folks. So today I want to walk you through exactly what happens to your IRA when you pass away, who gets it, how they get it, what the tax consequences are, and the one thing you can do this week to make sure your family's protected. Okay, so first let's get one thing clear, and this surprises a lot of people. Your IRA does not go through your will. So I could say that again. I've said it over and over again. The IRA does not go through the will. It does not go through probate. It is not controlled by your estate plan. So the IRA goes to whomever is named on your beneficiary designation form. So if you update your will and change who you think your IRA will go to, that does not change it. In order to change the beneficiary, you would need to change it with the IRA account itself. I can't tell you how important that is. So, and that form, by the way, lives at the IRA custodian or where the IRA is held, and the financial advisor that you work with can change it. So that could be the brokerage firm, your bank, could be the old 401k provider. And that form, if it names the wrong person or if it's blank, or by the way, if it just says my estate, your family probably has a problem. Okay, so let's walk through what should happen and when the beneficiary designation is correct. If you name your spouse as the primary beneficiary, which is what most married people do, and it's usually the right move, here's what happens. Now, I'll give you some different options here. So option A or option one, we'll call it the spousal rollover. Your surviving spouse can roll that IRA directly to their own IRA. It becomes their account, their money, their rules. This is usually the best option because it gives your spouse full control of it. And they can name their own beneficiaries that way, right? They can follow their own RMD schedule. And if they're under 59 and a half, they won't face early withdrawal penalties, okay? Option two here, or option B, whatever we wanted to say. So inherited IRA for the spouse. So alternatively, your spouse can keep it as an inherited IRA in your name. And this is sometimes useful if your spouse is younger than 59 and a half and needs to access the money without penalty. But for most people, the rollover is actually more clean. So one important note here, once your spouse rolls the IRA into their own name, they do need to go update their new beneficiary designations too. And who gets it when they pass, right? This is the step that gets missed most of the time because we just skip it and start taking it. And this is where Tom's story could have repeated itself in the next generation. Okay. Now let's talk about what happens when your children inherit your IRA. This changed significantly in 2020 when the Secure Act was passed. And a lot of people, and honestly, a lot of advisors still don't fully understand the new rules. And we still say they're new. There's a 10-year rule. And under the Secure Act, most non-spouse beneficiaries, so anybody that's not your spouse, including your adult children, must fully withdraw that inherited IRA within 10 years of you passing away. So there's no required annual distributions during those 10 years, but the account must be emptied or at zero at the end of 10 years. And here's why that matters. If you have $1 million like Tom did and you leave it equally to your two kids, so they each inherit $500,000, they each have 10 years to take it out. Every dollar they take is taxed at ordinary income bracket, okay? At the ordinary income bracket that they're in. If your kids, which is very common, are in their 40s and 50s, likely their peak earning years, that inherited IRA income can push them into much higher tax brackets. The IRS is going to get a significant portion of what you spent decades building if this is not planned for, okay? Obviously, that's not a reason to panic. It's a reason to plan. And let me get into this before we get back into the planning, but the Roth IRA versus traditional IRA and the big difference here. If you leave a Roth IRA to your children, the 10-year rule still applies, but and they still have to empty the account within 10 years, but the qualified distributions from the Roth, so whatever they take, are tax-free, so it's not pushing them into higher tax brackets. So this is one of those reasons, and it's a very powerful reason to consider Roth conversions while you're alive. You pay the tax now at today's rates. Your kids inherit an account that they can draw from tax-free for up to 10 years. That's a huge difference between leaving your kids a tax bill and I would say leaving them a gift, okay? So let me give you the 3 mistakes I see most often and how they can be completely avoided. So mistake number 1 is outdated beneficiary designations, just like I just said. That's Tom's story. Divorce, remarriage, birth of a child, death of a beneficiary, right? Life changes and beneficiary forms don't update themselves. So check yours, I would say today. So check it anytime. Check your account beneficiaries, please. Mistake number 2, naming my estate as the beneficiary. If your beneficiary designation says my estate, your IRA then goes through probate. And what does that mean? That means court, attorneys, time, costs, and the loss of the stretch benefits that a named individual beneficiary would have received. So I almost never say never, but in this case, we never name your estate unless your attorney has specifically told you to do so for your situation, okay? Mistake number 3, no contingent beneficiaries. Most people name a primary beneficiary and stop there. But what if your primary beneficiary passes away before you or at the same time? We've done horror story videos about that, right? Without a contingent beneficiary, the IRA defaults to your estate. And again, back to the thing we just talked about, let's name a backup. It takes 5 minutes and it matters enormously. And I'm going to talk about number 4. I'm going to add a number 4. And this may be a little controversial, but I feel like I have to talk about it. This just happened too. If you have your kids on as beneficiaries, it does not need to be equal. And what I mean by that is maybe one needs it more than the other. Maybe one of them would actually be hurt by inheriting money, either tax-wise or personally, right? So think of your kids. Maybe one is in a high tax bracket. Maybe if you give one money, that would actually be bad for them for a number of reasons. A very successful adult child of yours might not need it, and maybe another adult child couldn't handle it. So I guess the mistake here is just defaulting to an equal split because it feels right. Okay, so that's just something to think about. But here's what we want to do right now before you close this video. We put together an IRA beneficiary review checklist, and that walks our clients through and prospective clients exactly what to look for on every IRA and retirement account. So that'd be the primary beneficiary, the contingent, the account type, and whether your designations still reflect your original wishes. It might take 5 to 10 minutes to complete, and it could save you a ton of time. And again, from that situation that Tom's family found themselves in. So we can download it for free. The link is in our description below. If you go through that checklist and realize that something needs to change, or if you just want a second set of eyes on the overall retirement plan, that's exactly what we do. So you can book a strategy call through the link below. So if this is helpful, please subscribe. We put out content all the time for all the folks that we work with, and not just for them, but also the people that they love. And I'll stop there. This video, in the name of this video, take care of the family, take care of the beneficiaries, get them updated, and make it a great day.
Content here is for illustrative purposes and general information only. It is not legal, tax, or individualized financial advice, nor is it a recommendation to buy, sell, or hold any specific security or engage in any specific trading strategy. All investing involves risk, including loss of principal. Results will vary. Past performance is no indication of future results or success. Market conditions change continuously. Information here is provided in part by third-party sources. These sources are generally deemed to be reliable. However, neither 6 Point Financial Partners, Private Client Services, nor RFG Advisory guarantee the accuracy of third-party sources. The views expressed here are those of 6 Point Financial Partners. They do not necessarily represent those of Private Client Services, RFG Advisory, their employees, or their clients. This commentary should not be regarded as a description of advisory services provided by 6 Point Financial Partners or RFG Advisory, or performance returns of any client. The views reflected in the commentary are subject to change at any time without notice. Securities offered by registered representatives through Private Client Services. Member FINRA SIPC. Advisory services offered by investment advisory representatives of RFG Advisory LLC, RFG Advisory, or RFG. A registered investment advisor. Private Client Services, 6 Point Financial Partners, and RFG Advisory are unaffiliated entities. Advisory services are only offered to clients or prospective clients where RFG Advisory and its representatives are properly licensed or exempt from licensure. No advisory services may be rendered by RFG Advisory unless a client agreement is in place.